Good morning, everyone, and thank you for joining us today. A short disclaimer, the information presented here is for the purpose of informing the board. The views expressed do not necessarily reflect the views of the board or any board member. We are recording today's briefing. You will be able to access it on our website, www.ssab.gov. Feedback is welcomed and can be submitted via our email, events@ssab.gov. You can also tweet us using our handle @SSABGOV. And with that, I will hand it over to our board chair, Bob Jundev.
Good morning. I'm Bob Jundev, chair of the Social Security Advisory Board, and I want to thank you for joining us for this morning's policy briefing on marriage penalties in the SSA program. This public information sharing session will describe to the board how marital status influences SSA program eligibility and payments. By receiving the briefing, the board is not endorsing any particular position on the topics presented. And today, the Consortium for Constituents with Disabilities will be sharing its perspectives on the matters discussed. And so now to our speakers. We thank you for joining us this morning, and I'm going to hand it off so that you can provide your information and self-introductions. Take it away.
Good morning, everyone. My name is Claudia Center. I'm a white over 50s woman with glasses and brown hair. And I am the legal director of Disability Rights Education and Defense Fund. And I'm going to pass it to Kate.
Thanks, Claudia. I'm a white woman in my 50s, no glasses, and I am the director of Federal Income Security with Justice and Aging. And I'm going to hand it off to David.
Hi, I'm David Goldfarb, and I'm the director of Financial Security Policy at the ARC of the United States.
And Aisha? Aisha Lewis, a staff attorney with Disability Rights Education and Defense Fund, is joining as well, and she'll also be one of our speakers. And our bios are available on, I think, the SSAB website. Yes, Conway has placed in the chat. And we'll also be sharing several of our email addresses at the end of this presentation in case people want to get in touch with us. So thank you all for joining us, and thank you to the SSAB for inviting us to present on marriage penalties and Social Security Administration benefits. This is a huge issue to our constituents, and it's an issue that people feel has not gotten enough attention and that we haven't made a lot of progress on. And so I'm really excited to be here with you today to hopefully start a conversation that can lead to public policy changes. We're presenting today with speakers from DREDF, the ARC, and Justice and Aging. Next slide. But we're actually representing the CCD Working Group on Marriage Equality. And this slide has a list of all of the organizations that have been participating and working together in our working group from the Consortium for Constituents with Disabilities, which is the largest disability policy coalition working on federal policy in DC. Next slide. So I'm going to do an overview of the major marriage and relationship penalties in SSA benefits, and then I'm going to pass it over to my colleagues. And so this is, we've kind of broken it down in this slide to give the different penalties, because that's the only way I think that we can really approach public policy and reforms, is to break everything down into its pieces. But I do want to say that this gets much more complicated in practice. For example, if you have an SSI beneficiary who wants to marry a DAC beneficiary, or if you have two SSI beneficiaries who want to get married, but one or the other is leaving SSI or leaving and coming back to SSI. So this is infinitely complicated and difficult for disabled people. But I am going to go through an overview of the core penalties, but just know that they can get a lot more complicated than this. So the first penalty is that if two SSI beneficiaries are in a relationship and they get married, there is a 25% cut in the stipend and in the asset limit. And of course, the stipend is already below the federal poverty level, and we're going to talk about poverty later in our presentation. A related penalty is that if two SSI beneficiaries are unmarried but are deemed by the Social Security Administration to be quote unquote holding out, which we'll talk about more shortly, they also experience a 25% cut in the stipend and asset limit. Next marriage penalty is called the DAC penalty. So if there's two people and one is a disabled adult child beneficiary and the other person in the relationship is not a DAC beneficiary and is not receiving another Title II benefit, we'll talk about that more later. If they're in a relationship and get married, the DAC benefits end with marriage. So just out and out, it's an on-off switch. The third category of marriage and relationship penalties are when you have two people in a relationship and one is an SSI beneficiary and the other one is not. So if the couple get married, there's something called spousal deeming of income and assets from the non-SSI spouse to the SSI spouse, and that affects benefits, and we'll talk about that more in a minute. If this couple is unmarried, but found to be holding out, they would be subject again to spousal deeming, which again would affect benefits. And then finally, if the couple is unmarried and not found holding out, the resources from the non-SSI spouse can be deemed in-kind support and maintenance, which can affect benefits. So these are the core, the basic marriage penalties. Next slide, and I think the next slide is Kate.
Thanks, Claudia. So I'm going to talk about the marriage penalty in the SSI program. So that's the Supplemental Security Income Program, or Title 16 in the Social Security Act. And these are means-tested benefits for people with low income and few resources. So you can see here that under the statute, if two SSI beneficiaries are married to each other, they are considered as one unit. And that results in their benefits being less than what two separate individuals would get. So you can see here in terms of the benefit rate, the federal benefit rate for two unmarried SSI beneficiaries is $841 per month. That's the maximum each of them could receive individually. So if you have, for example, two unmarried SSI beneficiaries living together, maybe they're cousins or just roommates, but not in any sort of romantic relationship, and they each are receiving the federal maximum benefit rate of $841, their household would get a total of $1,682 per month. Whereas if this is a couple that's married to each other, they're both eligible for SSI, that couple's rate is $1,261 a month, which is 25% less than the amount that two unmarried SSI beneficiaries get. And likewise, because this is a means-tested program, there's an asset limit, and each individual SSI beneficiary gets an asset limit of $2,000, so they can have accountable resources above that $2,000 limit. And again, if these were two unmarried people, cousins, roommates, they each would have their own $2,000 asset limit. But if they are married, they are considered as a unit, and they have a total resource limit of $3,000. So again, 25% less than what 2 unmarried beneficiaries get. And this can be quite a penalty for married couples, where the amount is of that $3,000 limit is not like split evenly between them. You look at the assets they have in total. So if one of them has, $2,500 in savings and the other has $600 in savings, neither of them is going to be eligible for SSI because they're married. Okay, next slide.
Hi, this is David Goldfarb, and I'll just say, listening to Kate, the ARC represents people with intellectual and developmental disabilities, and I had the opportunity to lobby on a separate issue with Michelle from Oklahoma and her boyfriend, and unfortunately, they had run into this exact issue. Michelle and her boyfriend wanted to marry, and at one point were living together, and she ran into issues with her church saying that they were living in sin, but she couldn't get married because of her benefits. It ultimately led to her leaving the church, and she's since moved back in with her mother. But it's a very devastating for these individuals who would like to be married but really feel they can't as a result of the marriage penalty. In addition to what Kate was talking about, it's not just people being married, but you can be determined as holding out, and the statute says found to be holding themselves out to the community in which they reside as husband and wife. And since Oberfell, we've the Palms has made clear that applies to same-sex couples as well. And what this means is that even individuals that are not married can be determined to be can get that same 25% benefit cut, or as we'll discuss later, the spousal deeming. And so that creates a lot of fear and consternation in the community I represent as well. The regulations contemplate a little bit more than just holding themselves out, that they're living together in the same household. And if you go to the next slide, there's actually the regulations look at questions that would need to be answered if you are living with someone who is unrelated. And there's a POMS exactly on this issue, and they can ask for a statement, are you holding yourselves out to be married? Do you deny or accept that allegation? And they can ask a series of questions. The employees are asked to go through a series of questions to determine whether or not these individuals are holding out. What names do you go by? How do you introduce yourselves to your friends or relatives? How is mail addressed to you? What's on the bills and tax returns? And they can seek more information too, based on those answers, to make a determination of how they're holding out. So it's based in the statute about holding out, so you don't even have to be married, but it does move all the way into how SSA implements that policy. And I'll stop there, and next slide.
And here, do we have Aisha on? If you would introduce yourself and cover this slide.
Earlier, my name is Aisha Lewis. I'm a staff attorney at Disability Rights Education Defense Fund. And now we're going to turn to the disabled adult child, also known as DAC marriage penalty. And I just want to stop here and say that some people find these terms to be infantilizing because DAC beneficiaries are adults, and being called an adult child rubs some people the wrong way. So I'm primarily going to refer to it as DAC rather than disabled adult child. But that is the language in the statute. So DAC beneficiaries are people who are disabled before the age of 22, and they're a child of an insured parent who is either deceased or currently receiving SSDI or Social Security retirement payments. DAC benefits are a stipend, access to Medicare after 2 years, and a special pathway to Medicaid through SSI. And what that means is in many states, if you're receiving DAC, even if you don't meet the SSI income limits as a result of your DAC payments, you can still be able to get Medicaid and be treated as an SSI person. And DAC beneficiaries who get married, they lose their DAC. And that's written within the statute. The eligibility ends once you're married. There are exceptions. You're allowed to marry another DAC, someone receiving SSDI, a person entitled to old age retirement benefits, which at the earliest age is 62, or a person receiving another secondary Title II benefit. It's important to note here that SSI is not a Title II benefit. And so if someone on DAC marries someone with SSI, that doesn't qualify under this exception. And so that marriage would end their eligibility to receive DAC benefits. And one thing that makes it particularly hard for people, as you can see from the categories of folks who do qualify under the exception, it tends to be either other disabled people on SSDI or people who are retired, which at the earliest age is 62. And so people who receive DAC who've been disabled before age of 22, they're on this benefit at a time when many people want to have families. And I've spoken with a lot of people who are frustrated because most 22-year-olds don't want to marry someone who is 62 or older. People want to start families, and the way this penalty operates prevents that for many people. Next slide.
And now I think we're back to Kate. Is that right?
Yes, this is Kate, and I have the pleasure of talking about spousal deeming. So this is when an SSI beneficiary is married to somebody who is not receiving SSI. Because of these deeming rules, the income and assets of the non-SSI spouse, a portion of that is allocated to the SSI spouse when calculating their benefits. And also the assets of the non-SSI spouse is allocated towards that couple rate of $3,000. And this can have a big impact on the benefits, the amount of SSI benefits, and also the SSI spouse's eligibility for SSI altogether. As with an SSI couple, when you have an SSI beneficiary married to somebody who's not receiving SSI, the accountable assets of that non-SSI spouse are allocated to the couple, and that total is examined to see if it exceeds $3,000, and then the SSI spouse would not be eligible for SSI. So kind of back to the example I gave earlier of the non-SSI spouse having $2,500 in their bank account and the SSI spouse having $600 saved in their own bank account, then that total of $3,100 would put them over the SSI asset limit of $3,000 for a couple, and that SSI spouse would not be eligible for any SSI. And these spousal deeming rules apply even if the couple hasn't gone through a legal marriage ceremony, but if they are holding themselves out to the community as married, then these spousal deeming rules would also apply to that couple when they're found to be holding out. Next slide, please. So things get complicated here with calculating the impact of the income from the non-SSI spouse on the benefit amount that the SSI spouse gets. So generally, if that non-SSI spouse has less than $1,000 a month, again, this is less than the federal poverty level of income for one person in a month, that can cause the SSI amount of benefits that the SSI spouse gets to decrease. And there's a complicated calculation that I'm not going to attempt to do verbally here, but just to note that there is a tipping point. There is a point at which the SSI spouse would be earning enough to result in the SSI spouse to be ineligible to say that they have eligibility for zero benefits per month. And this is not like a lot of money here. This is even a modest amount of income by the non-SSI spouse of about $32,300 a year, which is less than half of the US median for annual income, brings that SSI benefit to zero. And they lose not just the cash benefits each month, but their eligibility for Medicaid, which for many people with disabilities and people on SSI in general, the SSI benefits is important. It's cash income. They need to meet their needs, but losing their Medicaid eligibility is just devastating in terms of their ability to afford and have access to health care and medications and things that are essential to their lives. Next slide.
Okay, so one of the things I was thinking as we're talking about, we're going to jump into in-kind support and maintenance, is that love is a journey. So we've talked about, people at the cusp of or who are married, things like holding out or actually being married. But obviously people meet, they date, and then oftentimes are looking to move in together. And one of the things that can catch people up if they are unmarried and they're with a non-SSI partner and they're sharing expenses is they can run into in-kind support and maintenance. Now, under the SSI statute and rules, you have income that can count against you, and basically when you're given food or shelter, that can constitute as an income reduction of up to a third of your benefit, and that's known as the in-kind support and maintenance rules. It's worth highlighting. SSA is looking at removing food from that list. That's currently under the proposed rule, but I think rent in particular, which is a big focus here, can count against the individual. And so from there, it starts to get a little complicated. It's when you think, okay, it's just food and shelter, that it can't be too complex, but in fact, it gets very complex. There are different rules for whether or not you're on the lease, or if it's your house that you're living in, or if you're living in your partner's home, but you're not on the lease. Will be two different tests, in fact. Not only can people get caught up if someone just wants to say help the individual on SSI because maybe they have a little bit more income, but even if they're splitting their expenses 50-50, if it's not done in the appropriate way, they can also lose their benefits. So if someone is paying the cell phone bill and other bills, but they're not paying for the rent, the SSI person's paying for the cell phone bills and other bills, but they're not paying for the rent, they can get caught up in a benefit reduction. And so it becomes a very tricky area, and we see it as an impediment to relationships forming. And so we wanted to include this example here as well, in addition to the more traditional marriage penalties.
Next slide, and then we go to Aisha.
Thank you. One thing we wanted to highlight as part of this presentation is the high poverty rates of SSI and DAC beneficiaries. More than 40% of SSI beneficiaries live below the federal poverty level, and nearly 36% of DAC beneficiaries also live below the federal poverty level. SSI and DAC beneficiaries are have the two highest poverty rates of all beneficiary groups. And so when we're talking about, groups that already live in poverty, stopping them from building relationships, it is really hard because most of us, we rely on our relationships. And when someone is in poverty, often it's even more important to have people that you're close with that you can work together to make it through. Next slide.
This is Claudia. One of the the biggest and most intense barriers to marriage and relationship equality for disabled people is access to Medicaid. So as we've mentioned before, SSI, Supplemental Security Income, provides Medicaid, and DAC, the Disabled Adult Child Benefit, provides a pathway to Medicaid. And in our society, we have chosen to use Medicaid as the exclusive vehicle to provide services and supports needed for people with significant disabilities. So Medicaid is not only, what most people think of as Medicaid, which is primary and preventive health care, medical services for illnesses and chronic conditions, but it's also durable medical equipment that is not covered by private health insurance. So things like wheelchairs and lifts. It is personal attendant care services and other home and community-based services not covered by private health insurance. It's services like supportive housing and employment services. So these are the services that allow people with significant disabilities to live in the community and not in institutions. These are the services that allow disabled individuals to be integrated in our society, which is, the promise of the ADA. This is respirators and ventilators. So people, even if maybe there's some other pathway to Medicaid that they could access, and that is increasingly possible with expanded Medicaid. It is just the fear of losing Medicaid. Medicaid is life and death. Medicaid is nursing home versus being in the community. Medicaid is everything for people with significant disabilities. So anything that threatens the path to Medicaid is terrifying for many of our constituents. And that is a big reason that we need to have public policy reforms in this area. Next slide.
Yeah. Oh, I'd just like to
go ahead.
Add on about Medicaid. We've spoken to people who it really is life and death and quality of life to be able to access those supports. People who can't get proper wheelchair coverage through private insurance. I spoke to one woman who needs 10 hours every night of nursing care to handle her tubes. In addition to help during the day with home health care. It's just not possible for people to get through private insurance, the things that they need to stay alive and stay healthy and stay out of institutions if they rely on those services. And so maintaining access to Medicaid is crucial. Next slide. Another thing we wanted to go over is the additional harms that are imposed by these penalties on disabled constituents. I already touched on earlier that it creates limitations in forming families. A lot of people fall in love. And unfortunately, I've spoken to some people who receive those benefits who feel that it's hard to even meet people and to get into relationships because they know that they can't go all the way where they'd like to. They have to tell people like, actually, I'm dating you, but just so you know, we can never get married. And that's really hard and, disheartening. Dating is already hard enough. In addition to not being able to get married, for some people, they want to be able to adopt children. Some people with significant disabilities can't have children, or others just want to adopt anyway. And it's very difficult for an unmarried couple to adopt children. In addition, there's a lack of social recognition of important relationships. I've had people explain that it's embarrassing. It's hard to explain what their relationship is. For others, it just makes them feel that they're left out. And a particularly important issue that a lot of people have raised is that it creates an inability to engage in religious practices that are important to them. For many religions, marriage is a sacrament, and people really do want to engage in that spiritual practice. For many people as well, living together unmarried conflicts with their religious beliefs. I spoke to one man who said that getting married to him meant getting right with God. And until he could get married, he just didn't feel that he was in the proper place. I've spoken with a woman who is very involved with her church, but struggles when she's teaching Sunday school and children ask about her relationship, and she has to explain, no, she's not married. And this creates this disconnection. People feel like their important relationships are treated as less than, and that they can't engage in the important parts of life that they really want to. I spoke with a young woman who was so excited to get married and have her big wedding, but was heartbroken to learn that she could lose her SSI benefits and not be able to take care of herself if she got married. Next slide.
This is Claudia. Aisha, would you also share about the immigration barriers that at least one of our constituents shared?
Yes, we've spoken with a constituent in California who met the love of his life in a meditation class, and they've been together for many years, but she lives in Argentina. She's an Argentinian citizen, and she can't come to the US unless they can get married for immigration reasons. And unfortunately, he has significant disabilities and needs a lot of medical supports that are expensive and difficult to receive. Luckily, he can get them in California, but when he spoke to his doctor about potentially moving to Argentina, his doctor said, you just can't do it. You would die. You wouldn't get what you needed if you moved to Argentina. And so they are living in different continents because of these marriage penalties that keep them from being together.
Thank you, Aisha. Now this slide is David.
Yeah, I'll just add a couple quick things. The ARC has run advocacy alerts and engagement on marriage penalties and trying to raise some awareness to Congress. And this really comes from our grassroots. I had the opportunity to participate in what's called our National Council of Self-Advocates. And I started talking about SSI assets. And before I could even get there, they stopped me and they wanted to talk about marriage. The marriage penalties are not just at the level of people who are about to get married or want to get married. People that are young and thinking about the future, they've just maybe turned 18 or 22 and they realize that they can't. It's very dehumanizing, and it affects them and their belief in self as much as it does these couples that are about to get married and are running into the quandary of the benefits. And that is a theme that runs through all these people who want to be independent and feel that this is a major barrier, and it really sticks to them, regardless of whether or not they have a boyfriend or girlfriend or partner right now.
And this is Claudia. I think sometimes the stakeholders have just thought, oh, it's too complicated. There's, it's so much to unravel to undo these marriage penalties. And that's why we're here today with the SSAB. We are the people who can unravel these and figure out how to go forward together. And so, this is just so urgent to our community.
And I'd just like to add in, it greatly impacts the people who are receiving the benefits, but it impacts their families as well. I've spoken to a woman who has been engaged for over 5 years. Members of her family have passed on, and they really wanted to see her walk down the aisle. There are church communities that support people and want to see their members of their communities able to engage in marriage. So it's not just the individuals, it's really, forming families can bring communities together, and it matters to their loved ones as well, to be able to see them do that.
Next slide.
So we wanted to highlight some of the legislation that's already been introduced into Congress that would address some of these penalties. And the first one is the SSI Restoration Act that was introduced in both the House and the Senate last year. And a couple of the provisions in this larger package of reforms to the SSI program would eliminate the marriage penalty, both for income, for the benefit rate and assets. So it would provide that a married couple receiving SSI would receive basically twice the benefit rate for an individual, and it would increase the SSI asset limit from $2,000 to $10,000 for an individual, and then from $3,000 to $20,000 for an individual, so that the asset limit for a couple on SSI would be double the asset limit for an individual on SSI.
Another bill is the Marriage Equality for Disabled Adults Act. And this one is aimed directly at DAC because the DAC restrictions are directly written into the statute. This bill would eliminate the DAC penalties and also affect people, protect people with SSI who marry a DAC recipient.
And then a couple other bills. There is a bill that attempts to address the marriage penalties in SSI directly, but only for people with intellectual and developmental disabilities. So as full disclosure, that's not something the ARC supports. We would want to see it applied to the broad disability community. Nevertheless, I will highlight that what's called the MAPSA Act is a bipartisan bill that would do away, if you are a person with intellectual and developmental disability, the spousal deeming issues, and also calculate the basically treat you as a single individual when you're calculating the benefit rate. And so you don't have to worry about that. And it would do away with, I think, the issues related to when two SSI beneficiaries married in the reduction rate if they both had an intellectual or developmental disability. I also want to highlight something we're working on a lot, which is the SSI Savings Penalty Elimination Act. This is a bipartisan bill to raise the asset limits from $2,000 for a single individual and $3,000 for the married couple to $10,000 for an individual and $20,000 for a couple, as well as adjusted for inflation. And built into that is a reduction in the marriage penalty related to assets, because it's not $15,000 for a couple, it's $20,000. So you don't have that reduction. It's just a twice the amount of the single rate that that $20,000 equals to. And so it does address the marriage penalty in that form.
Next slide. So on this slide, we're talking about a few things that the agency could do without congressional action. Although, as you can tell, many of these rules exist in the statute. So we are going to need legislative action ultimately to remove all of these penalties. And, you know, we believe that bipartisan legislation would be the best path to success. But this slide talks about things that the agency could do on its own without Congress. So one thing that the agency could do is to clarify the holding out standard. If you look at the statute, and David quoted the language earlier, it really is about holding yourself out as married. It's not about a functional analysis of whether two people you know, live together in a functional manner similar to spouses. So the agency could clarify the holding out standard and direct staff to only apply this to affirmative representations by both individuals of marriage under state law, and to articulate a safe harbor for couples who are living together so that they can feel comfortable in their relationship. Even if they can't yet get married, they can at least be together without stress through a safe harbor. And I listed a case here from 2019 in the citations that talked about how the functional analysis is not appropriate for the holding out standard. It's about affirmative representations. And the agency could do a lot to make clear to staff that this holding out standard has very limited, or should have very limited, application. And then spousal deeming, I think that's Aisha.
Yes. So one thing that as SSA could do to mitigate the effect of spousal deeming is allow a spousal living allowance. This, which would be a deduction from the non-SSI spouse's income. This would be analogous to the parental living allowance that's already in place for SSI. And this could be done by regulations. The SSA has authority to discount certain income in the interests of fairness. And, we would argue that allowing some allowance for what the spouse needs to live would be something as a matter of fairness, as it's done for parents. In addition, if the apologies, as Claudia mentioned earlier, revising and clarifying the holding out standard would make it clear for people, and so they don't have to worry about spousal deeming applying if they are within the framework that's been set forth. Another
and, I just want to jump in here, Aisha, sorry. I wanted to share that the paper that we've linked to, which was written in 2003 by Social Security Administration, talks about the spousal living allowance as being the federal benefit rate amount. But really what we think is it would be more fair to use the IRS standard deduction divided by 12 as the spousal living allowance, particularly given our reality and the cost of housing and just how everyone's struggling to get by. The IRS, studies what should be a standard deduction, and we think that should be used for these households. But go ahead now, Aisha, for the RFRA.
Right. And just to sort of piggyback on that as well, it's been well demonstrated that people with disabilities have higher expenses, disability-related expenses than other people. Also, it's been the areas where people with disabilities spend more money, like healthcare, are some of the areas that have experienced the highest inflation. So it really would make a big difference. And, as we talked above, it doesn't take that much income to have spousal deeming cause people to lose their Medicaid, and that can be life-threatening. For the next point that the agency could do is create an administrative process for RFRA claims. RFRA is the Religious Freedom Restoration Act, and it is a federal law that applies to the federal government, requiring that the federal government respect the religious beliefs of people and make accommodations for people's religious practices and beliefs where feasible. And as I mentioned before, a lot of people have religious beliefs around marriage, and there should be a clear mechanism for people to make their religious freedom claims to the SSA if that's something that they'd like to pursue.
And this is Claudia, just to jump in, the RFRA standard is very strong, and it applies to other federal laws. And so the federal agencies are supposed to modify or not apply federal laws where it interferes with religious practice. And the only defenses are quite high, fundamental alteration and undue hardship, I think. Is that right, Aisha?
Yes, it's a very stringent standard. It's been referred to by courts as a super statute. So it sits on top of all the other federal laws. And, because the SSA, like all federal agencies, is subject to it, we think that the process should just be clear and transparent for people. Another thing that would be helpful is better public education and guidance on these extremely complex rules. Many people don't learn about the DAC penalties or the SSI penalties until they're engaged in planning their weddings. And so having clear education and guidance would help people plan their lives properly. I remember reading an SSA guidance document that was talking about how marriage affects benefits. And on the section for DAC, they just said, instead of setting it out fully, they said, you should call SSA to get an answer to this. And that's not acceptable. There are many, many people who receive these benefits, and it's not, it doesn't make sense for all of them to be calling the SSA about their questions. There should be something that's set forth for people to follow. And finally, we would, actually, Claudia, could you talk about this?
Yeah, that's actually for Kate and I think, but
before you get there,
go
I'll
ahead,
just
David.
add on the public education and guidance, just from my network, there is a lot of confusion. Now, it's not just about the marriage penalties, but again, they change. A lot of people start off as SSI beneficiaries, then they might become SSDI beneficiaries, or they might become DAC beneficiaries, depending on the process of their parents aging or developing a work record, depending on which one. People don't know. So we have situations where people couldn't get married, and then it wasn't until years later that they learned that because of their benefits change, that they could get married. And the same applies with holding out. There's a lot of fear and consternation in my community about, well, if we're together, are we going to get in trouble or not? And what kind of advice can be given to individuals that want to be married, up until having a real law change. How far can they go in terms of showing their commitment before SSA is going to bring the hammer down on them? That is a source of a lot of consternation and fear. So public education will be very helpful to our community.
And this is Claudia. We understand that most DAC beneficiaries who lose their benefits, because there's a number published, by SSA, we understand that most of those people lose their benefits because they didn't know that they would lose their benefits when they got married.
And just to speak to this last bullet point here on the comprehensive report on penalties and reforms from the agency, we would like to call on SSA to set up a national disability forum. We think it could be really helpful to hear from experts and people with lived experience about these issues. And also to author a report on these penalties and possible reforms. The last time we think that someone from SSA published anything about this is a Social Security Bulletin article from 2003. So that was almost 20 years ago, and we feel like this issue has not been studied and reported on to the extent that it should be.
And Kate, wasn't there a prior report on a different topic that is kind of a model?
Well, I think that's our call to the Social Security Advisory Board, is for you also, the board, to look at this issue in the way that you have other issues in the past, such as the representative payee program, and also a report you've done on in-kind support and maintenance recently. We think those kinds of focus from the Social Security Advisory Board in terms of talking about possible changes that could be made to address these marriage penalties would be very helpful.
Thank you. Next slide. This is a slide with the DREDF graphic for End the Love Tax. We published this on Valentine's Day, and like the ARC, we've done some action items around this with our constituents, and this is just of huge importance to our community. Next slide. So we've come to the end of our formal presentation, and we're happy to answer any questions. And I think we could also stop sharing the slides, I think.
Hi, this is Bob, and thank you very much. This has been extremely informative, and I'm wondering, I know that we've had some questions from the community during the presentation. on our chat function. And some of those have been answered and some of them haven't. But I saw one that had to do with basically, in a sense, challenging the assumption that people don't financially end up in a better situation if they're living with someone else. And I'm wondering if you wanted to respond to that directly.
So I think the assumption is that around economies of scale, right? That if two people are married, that it doesn't cost as much for them to live separately, right? Technically, it's maybe like a 1-bedroom apartment rather than a 2-bedroom apartment. So there's economies of scale. But we feel like that isn't true. And as Aisha spoke to the difficulties or the expenses of people living with disabilities, and just the cost of living today, particularly with SSI benefits, people being expected to live below the poverty level when the amount of benefits, the federal benefit rate for an individual is less than the market rate for a 1-bedroom apartment in any county in this country, basically, and really also above the rate, the couple benefit rate for a 1-bedroom apartment in most places in this country. So, I think that we are saying a couple should be treated like two individuals, that they need that income to live on, and that we're not saying that, other two SSI recipients who are living together like siblings or cousins or roommates or whatever should be treated like a couple and should be penalized for living together. We're saying we want to end the marriage penalty and have everybody be able to receive the full individual benefit rate.
And this is Claudia. I would also add that, I live in San Francisco. My colleagues live in the Bay Area or in the DC area, and it is very common for people non-disabled people not on any benefits, to live as roommates, to share expenses. So why are we treating disabled people differently?
And one thing I would like to add on as well is that our country recognizes a constitutional fundamental right to marriage, and these rules, penalize that, and it's important constitutional right. And like Claudia said, many people have roommates, many people share expenses and aren't penalized. So we should not be penalizing people for doing the same if they're married.
And I think Kate kind of hit on that, especially the low benefit rate. It's not that they want to share expenses, they have to in order to survive. They have to share expenses with others, live in group homes and similar. And I'll just say, again, this is not the economic analysis part, but no one in my community says, oh, we're going to have an economy of scale by getting married, so let's do it. It's the exact opposite. So however it might be in terms of studies, people do not see this in any way as a benefit. They see it as harming themselves by getting married.
Thank you. I wanted to ask other board members if they had questions.
Yeah, I have, if I can, Bob, this is Nancy Altman.
Hi, Nancy Altman, yes.
Member of the board. You've made a really, I think, compelling case for the, and a clear case for the costs and the invasiveness of these various penalties, or this marriage penalty. A question I have, and I don't know that any of you were really in a position to answer it, but my understanding is that it's also very burdensome on the agency and very expensive to administer. It's the deeming, it's the complexity of it. I don't know if you have thoughts about that or have any insight, but given how squeezed Social Security Administration budget is, this is both would be a very excellent policy change, both through regulation and through legislation.
Yeah, particularly for the SSI program. So the spousal deeming calculations are incredibly complex, and the in-kind support and maintenance calculations are incredibly confusing. And often result in underpayments as well as overpayments for people. So, and then, when they're doing the marriage, the calculations for the benefit rate for a married couple can also be very complicated. I heard yesterday from somebody who's helping a veteran, and both the veteran and his wife are eligible for SSI, and the amount of benefits he's receiving from the VA just went up a little bit. And that means that both he and his wife are receiving less in SSI. And he was very upset about that, right? He was like, it makes sense that my SSI is going to be reduced because I'm getting more from the VA, but why is it impacting my wife then as well? So if they were, each looked at as an individual, then yes, his benefits SSI would be reduced for that increase, but his wife's SSI wouldn't be reduced as well. So I think that these calculations, particularly for the SSI benefit rate, are very complicated and cause a lot of administrative headaches for the agency.
You make a good point also about program integrity, that it would go in a good direction of stopping overpayments and underpayments.
Are there other board member questions?
Yeah, so I have one question related to the implications of the policy changes that you're suggesting. One implication, of course, is to affect the ability to marry and so on that you've pointed out for existing beneficiaries. But when Social Security or other agencies like Mathematica and so on do policy analysis, they also consider what is known as induced entry. In this case, it would be induced eligibility. Have you made any estimates as to the overall effect of the policy changes on induced eligibility, and then the overall cost to the budget of what that would bring forth? Or has anybody else done such an analysis?
This is Claudia. I think there was an analysis of a financial analysis of removing the DAC penalty. I'm not recalling it right now, but when bills are introduced, they do a financial analysis. David, do you happen to remember that one? I thought it was negligible.
I remember that it was quite small, and it would not change the insolvency date of the Social Security Reserve Fund. I can send the scoring. It was done by SSA, so I would imagine that they also have a copy, but we can share that.
Yeah, my recollection is that I believe it's OAC, the Office of Chief Actuary. They have done scores on, as they mentioned, the DAC marriage penalty bill, but also if you go to the scoring on the SSI Restoration Act, they did a full scoring of that, and there's data in there. Now, it only gives you a cost estimate in terms of its impact. It doesn't go into questions of inducement. So we don't really have an answer there. I don't have the mathematic capabilities to do that. So it's a good question.
And just to mention that question came from board member Jagadish Gokhale. Kim Hildred, do you have any questions for us before we?
I was just curious about, and I should know this, but I don't. The fact that you talked a lot about the very serious impacts on individuals based on losing their Medicaid because of the changes to SSI. And I'm just curious about the tie between SSI and Medicaid. Is that a state by state determination?
Yes.
Yeah. Oh, go ahead, Kate. You'll know this better than me.
Yeah, so there are still 9 states where individuals on SSI still have to go through that state's Medicaid eligibility process.
Mm-hmm.
But by far, obviously the vast majority of states, being on SSI makes you automatically eligible for Medicaid in that state.
Mm-hmm.
So that kind of automatic eligibility connection is really important for people receiving SSI. And there are fewer and fewer states, as time passes and 1972 becomes farther and farther in the past, more and more states see the benefit of having SSI eligibility automatically tied to Medicaid in their state.
I was just wondering. Go ahead.
Some people, who leave SSI Medicaid can get on expanded Medicaid, but then that can cause a gap in coverage. I know California has a rule that you have to wait. They won't do a gap in coverage. They will cover that gap, but that's not true everywhere. And of course, not every state has expanded Medicaid.
It was just curious to me whether, because of some of these marriage penalty issues, have some of the states or any of the states kind of looked at this in terms of, okay, maybe on the eligibility side, we want to, stay connected to SSI, but when there are some of these decisions, maybe we don't. I don't know if any of the states are looking at that or not.
So there are spousal impoverishment protections built into the Medicaid statute. And I think it's one of the purposes that we see SSI is it is the lifeline to keep people in the community and not become institutionalized. So when they're talking about giving up their benefit, it's probably the case that they might be able to qualify some other way through Medicaid, but it's not the case that they would have the funds or ability because of wait lists to remain in the community. And that's sort of what SSI does. And generally the pathways for SSI tend to be better than wait lists for other Medicaid services. So they do put themselves at risk of institutionalization. And I think that's another underlying factor that's perhaps less discussed, but is out there.
Okay, thank you.
I see that we've come to the end of our time. I wanted to thank the panelists for bringing this very important information to us for our consideration and sharing it with those who have attended. And I want to thank everyone who has attended today. And hopefully we will be able to hear more about these issues going forward. So on behalf of the Social Security Advisory Board, I want to thank everyone and have a wonderful afternoon.
Thank you so much.
Thank you.
Thank you.